All
Oh,
righty. Okay, we are good to go. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation. We're here to provide information for you today in regards to inherited property, clearing title, deferred property taxes, and other probate concerns. I know that's a long title, but my name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation. We are one of the partners in the A Month of Service collaboration, but also included, we have the City of Houston Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partners with the Harris Central Appraisal District, we have Ms. Mabel Menifee, as well as Ms. Shay Pinkowski with the Harris County Tax Assessor Collector's Office. In addition to that, included in the partnership, we also have Lone Star Legal Aid, the Earl Carl Institute, and Houston Volunteer Lawyers. And together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information, that don't know where to go for available resources. So several years ago, we decided to collaborate and come together and pool a lot of our initiatives and try to see if we can create a larger impact and try to reach as many people as we possibly can and get as much information out to the communities that we all serve as best as we can. So this platform has worked out tremendously well for us over the last several years. We did have to adjust to the virtual platform versus to being in person due to the pandemic years ago. However, we will slowly try to integrate hybrid presentations where we're in person and doing the Zoom sessions slowly but surely. So look for us to come soon in a neighborhood near you. But again, we provide these workshops on a monthly basis. All of the workshops that we do provide are for educational purpose only. Any of the presentations that are legal in nature, please know that they are not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid, the Earl Carl Institute, also as well as Texas Legal Services Center and Houston Volunteer Lawyers, should you find yourself in need of any civil legal assistance. There is a pre-assessment opportunity that you can do through the month of service collaboration, and Ms. Cecile Carlson can kind of give you some information about that as well. But do know that this is your opportunity to ask questions of the professionals that are experts in their area of expertise as it relates to clearing title, the property taxes, and probate issues. Um, but we do want to try to protect your privacy as best as we can. As we are on a public platform, we do record the session as well as broadcast live on our social media channels. So we want to try to want to be mindful of your personal information kind of getting out there. So again, ask your questions to be as general in nature as you can, as opposed to giving real specific details about your specific situation. However, there are a couple people that are monitoring the chat from our partnering organizations that can potentially assist you in other regards. But we do go over all of the questions at the end of the presentation because as they're giving their presentation, some of the questions that you may have may be included in the presentation that they're giving. So we wait till the end to ask those questions. So feel free to type your questions into the chat. You can wait until the end, unmute yourself, or raise your hand and we can call on you and you can ask your questions directly. If you are joining us on our social media page, then you have the opportunity to please type your question into the comment section and I'll make sure that it gets read aloud at the end as well. There were a few questions that were emailed to me in advance when some of you registered, and I'll make sure that those questions get addressed as well too. So on behalf of the collaboration, we want to thank you all for joining us this afternoon. If you're joining us for the first time, we want to welcome you. If you've come back before, we want to thank you for your continued support and engaging all of our presentations. So without further ado, we're going to go ahead into our introductions and then we're going to move on into the presentation. There's a lot of information that's going to be covered here today as it relates to inherited property. Um, do know that we're more talking about the after someone passes side of things. If you need more information about what to do or how to pre-plan or how to uh, make preparations, we do a monthly wills and estate planning class the first Thursday of each month. And that one goes over all of the documents that actually make up an estate plan and why you actually need it. And then a secondary part of that is to how to draft your own will and transfer on death deed. Again, we do those the first Thursday of each month. So that's what happens like before anyone passes. We're here today to talk about what happens after someone passes. What's the probate process like? What happens if somebody passes with a will, without a will? What if they've had deferred property taxes? What payment options are there? How all of that kind of ties in together when you've got multiple heirs for for a single property, and how do you do that? What do you need to do? So we're here to address all those kinds of concerns for you today. So again, we want to thank you all for joining us. Ms. Cecile, why don't we have you introduce yourself first, and then we move right on into the presentation.
Sure thing. Thank you so much, Nia. Good afternoon, everybody. My name is Cecile Carlson. I'm an outreach coordinator here with the Department of Neighborhoods, and we are one of the partners in the A Month of Service collaboration. I want to thank everybody for being here, for taking time out of your day. Thank you to our presenters and to our audience for being here. Lots of really good and important information. Make sure to ask those questions like Nia said. And in regards to our will and estate planning services, I'm going to go ahead and put my contact information in the chat if anybody needs to get connected to fill out one of those pre-assessments. I'm more than happy to walk you through it or answer any questions that you may have. And I'm going to go ahead and pass it on to our presenters. Thank you all so much for being here today.
All right. Miss Mabel, you
All
there?
right. Good afternoon, everyone. My name is, let me get that up first. My name is Mabel Menifee, and I am with the Harris Central Appraisal District. I want to also thank my colleague Ashley Washington, who is a specialist in our exemptions department, who's also going to be on the call with us today, and she'll be able to answer your questions regarding certain parts of the exemption process and the Texas Property Tax Code. Now, one of the reasons I'm glad you're participating is because we're going to talk about issues that are related to inheriting property, but also it's just going to be good information if you are planning or are currently a homeowner. So particularly with exemptions and the process of making sure you're not overpaying taxes and that you're also not incurring any future expenses because you are operating on exemptions that are not yours, but might have belonged to the previous owner of the property. So we're going to get into that as well. So you guys want me to go ahead, and then do we want to go with, and then I'm going to be followed by my colleague down at the Harris County Tax Office, Shay Pinkowski, because we are kind of the different sides of the property tax. When we do the evaluations, administer exemptions, conduct the hearings and appeals, and then the billing and calculations and all of that, once we're done, is done by your local tax assessor collector. So there's a lot of things you're going to be able to learn from both of us.
Okay, Miss Shay.
All right. Hi, everyone. Good afternoon. My name is Shay Pinkowski, and I'm with the Office of Annette Ramirez, which is our Harris County Tax Assessor Collector's Office. We're the department that normally handles the actual billing and receiving of funds for your property taxes. So I have a lot of good information for everyone and some information on how to set up payment agreements and things like that. But as Ms. Mabel mentioned earlier, we are two sides of this very similar coin where it deals with property taxes. First, it goes through the appraisal district, and then afterwards it comes to us, and we're the ones who send out those bills to you. But just to get a good idea and a good information for how the process is begun, how your taxes are evaluated, and where they get those numbers from, I'm going to go ahead and give it over to HCAD, and HCAD's going to go into some further detail about, the valuating of the property taxes and exemptions and information regarding that might be of good assistance to you. So I'm going to go ahead and pass it on to Miss Mabel, and we'll get that started.
No,
Miss Lisa.
Wrong seminar.
Oh, Miss Lisa,
Wrong,
you're right.
wrong one.
I'm so sorry. We went full
So,
circle, Miss Lisa then.
That's
so
okay.
just to give you guys a little bit of background, the reason we have the tax office and the appraisal district included here is because once somebody actually inherits property, in addition to there potentially being multiple heirs, people have had questions about property tax issues that related from inherited property that they've gotten, whether somebody has had deferred property taxes or other exemptions that were on the property that fall off, or now there's a huge tax bill that's available. How does all of that work into the probate process and the inherited heirs that have inherited the property and the exemptions that they are eligible to take advantage of being the heirs of a property that they now own. So that's why we act. So in case you guys were wondering, why does the tax office got to do with probate and whatever?
Mhm.
Now you kind of know.
That's
So
why.
we
That's
have
right.
we have had those questions that have come up, and all of those things kind of relate to one and the other, and one subject kind of rolls into another. So we wanted to make sure that they were here to give their expertise and their point of view from that perspective as well, but also still give you guys a little bit of background about how bills and things are like that are calculated and who actually gives you the bill, because so many people mistake that the appraisal district is the one that sends out the bill, and that's not the case either. But without further ado, Miss Lisa Nelson with the Texas Legal Services Center, and she's going to be giving you all the information about inherited property and probate concerns. So, Miss Lisa.
Thank you. Good afternoon, everybody, and thank you so much for joining us today. I apologize in advance. I'm going to have to leave a few minutes before 3. I've got a meeting, but I already have started answering questions in the chat. So if things occur, I can't answer questions while I'm talking, of course, but once I'm done, I will carefully monitor the questions and hopefully I'll be able to answer everything. Miss Nia is able to reach me if something comes up after I have to leave. So,
Okay. All right.
and so I'm here to talk about clearing title and other probate concerns. It's a little bit of a mishmash because we added information on what to do, how to handle probate after someone has passed. We have 2 great workshops on the importance of estate planning, and this is your follow-up to know what happens.
Swap you view your display
Oh,
settings, Miss Lisa.
okay, thank you.
Display settings.
Display settings and swap.
Swap.
There, got it?
Click
No,
it.
I need to swap it again. Or is it working now?
No, we still see your slideshow.
Okay. Is it working now?
Mm-mm.
I wonder if let me end slideshow and start over. Maybe that'll do it. Okay. I have to laugh because how many years we've been doing this on Zoom and I still run.
And we still, yeah.
Okay. Come on. Do I have it now?
It's just on the PowerPoint screen. Now, there you go.
Okay, great. Thank
Yep.
you. So I'm going to give an overview of the probate process. And then the main focus of our presentation is how to handle inherited property. So I will explain how to handle it and also how to prevent that problem in the future, how to make sure that any property that you choose to pass on to your heirs happens smoothly. And then I will pass it over to my friends to talk about property tax concerns because there are a lot of questions about how you can get the property tax exemptions that you are entitled to. I'm at Texas Legal Services Center. We've been around for almost 45 years, and we're a statewide nonprofit organization. Our office is in Austin. I am located in Harris County. I work remotely, and we provide legal advice, advocacy, representation, and education to underserved people across the state. We've got more than a dozen practice areas. We have several that focus on family law concerns. We have victims of crime. We have a veterans issue. We have one for people over the age of 60. So we touch almost every aspect of civil law that impacts low-income Texans. And our mission is to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. I will put my information again in the chat afterwards, but there's my email, and our website is tlsc.org. I'm a staff attorney with Texas Law Help. Texas Law Help is a comprehensive website that tells you anything you need to know about civil law. It also includes forums for those people who decide to represent themselves, and we have attorneys available to provide advice and information. The first thing with probate is to learn a lot of new vocabulary words. So the decedent is the person who passed away. If that person passed with a valid will, it's considered testate. And it's intestate if someone passes away without a will. Testator is the name for the person who is signing the will. And a will is a legal document that states how the testator's property is to be distributed at death. Estate is your stuff. It's your property, both your real property, your real estate, and your personal property that you own at the time that you pass away. Probate is the court process of winding up a person's affairs. It's called probate whether there is or is not a will. But if someone passes without a will, it's called administration as opposed to probate. When you have a will, you name someone to be your executor, who is the person responsible for wrapping up your affairs and distributing assets to the beneficiaries. If there's no will, the person is called an administrator. I tend to use personal representative because that applies regardless of the type of probate procedure. And the heir or the beneficiary are fairly interchangeable, and that's the person who's inherited either by the terms of a will or by law. There are a lot of misperceptions, and I'm already seeing another one I need to add because this comes up all the time. But first of all, your power of attorney is only valid while someone is alive. Once they've passed away, the power of attorney is void. So being the power of attorney of someone means nothing once they pass away. A lot of people think they don't need wills if they're married because Texas is a community property state. That is true, but the surviving spouse has a life estate in the deceased person's home, even if it's separate property. So if you were married to someone who owned a home before the two of you got married, it may still be considered their separate property. However, that surviving spouse has a right to remain in the home for the rest of their life. They do have to maintain the home and pay property taxes. An executor or administrator may be disqualified by law if they are under the age of 18 or they don't live in the state of Texas. And I want to add that you absolutely have to probate a will. A lot of people think that if there's a will, it's all done. This house is mine now, and that is not true. You do have to go through the formal probate process. I always am going to recommend that you have an attorney prepare your will. Texas law does allow you to prepare your own will. You can have one called a holographic will, which is when it's completely in your own handwriting. I recommend going to our website, texaslawhelp.org, and it gives you the instructions on how to have a proper handwritten will so that your loved ones can't file any type of will contest. We also have forms that were prepared by the Texas Supreme Court that allows you to prepare your own will. Please do not try to save money by using something like LegalZoom or another online site to prepare your documents. Those are meant to help the widest amount of people. It doesn't look at Texas law at all, so it absolutely may not be valid. It is best if spouses have two separate wills. And you want to keep your will in a safe place that your loved ones, or at least your executor, knows about. If they can't find your will, it's the same as not having a will. You can have a copy of a will probated, but it's more difficult. Texas law presumes that a will has been revoked if the executor cannot find the original will. If you die without a legally valid will, the law determines who will inherit your property. It does not matter if you told everybody in the world that you want this niece to inherit your house or that you want this person to get your car. If you do not have a will, the law determines who inherits. If you can't find a will, you can file an application for administration. You can file an application for administration, either dependent or independent. An independent administration is not a difficult process, but everybody has to agree. If there's one party who doesn't agree with going along with it, you will have to file dependent administration, which is extremely expensive and time consuming. In extremely limited cases, and I'll go over them in a moment, you can file a small estate affidavit. In Texas, you are required to have an attorney to probate a will or to have administration of an estate. It does make it more expensive, but it's the best way to proceed because this is not a simple process. An attorney will know the best way to manage your loved one's affairs. Probate assets are property in the testator's name that pass through the will, such as your real estate and your personal property, which would be your household items, your furniture, your clothes, all of those things. Texas also has what is known as non-probate assets. Non-probate assets pass in accordance with the terms of a contract. This would be any life insurance policies, retirement plans, or payable and death accounts. A great secret about Texas law is that if you have payable and death beneficiaries on all of your financial accounts and a transfer on death deed for your home, your family may not need to probate your will. You absolutely want to have a will no matter what, because many times someone thinks that they have taken care of all of their assets, and it turns out there's a retirement account from a job that they had 30 years ago that they just completely forgot about. So your family does have to go through the probate process then. But I recommend to everyone that this afternoon, tomorrow morning, give a call to your bank, your insurance companies, any other retirement accounts, anything like that. Make sure you have payable and death beneficiaries. You can have a transfer on death deed for your home, any other real estate you own, and it makes the process so much simpler. Texas probate is not complicated. It's a lot less expensive than it is in other states, but it does take time. And Harris County, even if you have a perfect will and no one is fighting, it can be 6 months before you get in front of a judge. So with having these beneficiary designations gives your loved ones the opportunity to access your assets much sooner. Small estate affidavits only work in limited circumstances. There is a big misunderstanding because you can only do a small estate affidavit if someone doesn't have a will. So and a small estate affidavit is the only probate procedure in which you may not need an attorney. Some counties don't require you to have an attorney. So people will think they didn't have a will, that I don't have an attorney, we're going to do a small estate affidavit. They only work to transfer real property if you are the surviving spouse or a child under the age of 18. If you're a surviving adult child, you cannot use the small estate affidavit to transfer your home. Everybody has to agree with a small estate affidavit, and that means that all of the heirs have to sign the affidavit stating that they agree that these are the assets of the deceased person and they agree with the way it's going to be distributed. And you also have to have 2 disinterested witnesses. Those are 2 people that knew your family history well, who cannot legally inherit from you. Again, you cannot do this procedure if the person left a legally valid will. The value of the assets has to be greater than the debts of the estate. So if someone passes away and they have $30,000 in assets, but they have $40,000 in medical bills, tax bills, credit card bills, they cannot use a small estate affidavit. And another important thing to remember is that the estate excludes the homestead. Your homestead is exempt, and the rest of your estate has to be less than $75,000. How probate works, first of all, is you talk to an attorney and they determine that they will make sure that the will is valid. They will get an understanding of what all the property is in the estate, and they'll determine the correct way to proceed. So if there's a will or if an administration is the appropriate way to go, attorney starts by filing an application to open the estate. The application has to be on file for 10 days before they can schedule the court hearing. That does not mean you're going to court 10 days after they file the application. Like Harris County, it's months. You go in front of the judge. It's a very simple, usually less than 5-minute appearance, either in court or by Zoom. And the attorney grants either the application to probate or an application to administer the estate. And the personal representative receives letters. The letters testamentary or letters of administration are an official court document that states that they have the authority to manage that estate. So one of the very first things they do is they get a tax ID number, and they take the letters plus the tax ID and go to a bank to close the deceased person's account and open an account for the estate. They most of the time when someone passes, a bank closes an account within days of the person passing. They don't wait till they're notified or anything like that. They find out that the person has passed and the account is closed. So then the representative is able and has to open up a new account that is titled in the name of the estate. So it would be the bank account for the estate of John Smith, deceased. The attorney notifies creditors. Please do not think that if someone passes and they have bills, do not think that you have to pay them personally. The administrator, the personal representative, is absolutely not responsible for those debts. Now, you do need to pay the bills, insurance bills, utility bills, things to keep things running. But all other bills, they have to go through a court approval process. They have to file a formal claim with the court, and it has to meet very strict legal requirements. If they don't meet those requirements, you do not have to pay that debt. And then the final step, if it is probate or independent administration, is that the attorney and the personal representative prepare and file an inventory. An inventory is an accounting of everything the person owned and any things owed to them as of the date of death. I added this slide because every time I give this talk, people want to say, well, what about a trust? A trust is a legal document that also states how a testator wishes their property to be distributed. And it can include everything you own. Trusts are very complicated. It's very frustrating that people will go to a website and prepare a trust. And because that website, it doesn't care. You know, they just want you to purchase their services. They just want you to purchase those documents. If the trust is not done properly, it is nothing more than an expensive stack of paper. It is extremely expensive to have an attorney prepare your trust. That is because it needs to be prepared correctly. If you have a good attorney, they have someone in their office that will make sure all of the property is properly transferred to the trust. A good way to look at a trust versus a will is the trust, all of the costs are up front because you do not have to probate a trust. A will, the costs are during the probate process. So it's important not to create your own trust because it might not be a valid trust, and it is very complicated and confusing to transfer things properly to a trust. There are some great reasons for having a trust. Trusts are commonly used to protect someone's assets so they can qualify for Medicaid. That's if they may need to go into a nursing home. Trusts are great if you have a blended family and you want to make sure your children inherit your estate. Trusts also allow you to have control after your death. You can control when people receive property. You can determine that property remains in your trust long after you pass away. A lot of people think trusts are better because they don't go through probate. If you have a good will, probate is not complicated and it's not all that expensive. You know, most people, you know, their biggest concern with probate, with trust is their home. And we have a lot of, there's a lot of confusion about inherited homes. I can tell you, you know, numerous times when we're out in the community, somebody comes to me and they think they own their home because their spouse left it to them in their will. They don't own their home. The spouse's estate owns the home. You have to go through that probate process. So it's really, a lot of times, people don't know that they don't have clear title until a hurricane or a winter storm hits and they need to apply for FEMA or for state assistance for repairs. You will not qualify for any assistance if you haven't probated the will or if you haven't done another process to transfer the home into the current owner's name. Additionally, you aren't eligible for any property tax exemptions or deferrals if you're not the owner with a clear title. Clear title means that no one else has a financial interest in your property. The most important thing about clear title is that there's no question of ownership, and the ownership history can be easily traced. Somebody can go to the deed records and look through, all the way back to who the original owner was and how it passed throughout time. A title is called cloudy if it's not legally transferred or deeded to a subsequent owner. This happens all the time when someone dies without a will or the family didn't manage the estate to transfer the house properly. Title is not a piece of paper. Title is a person's legal right to the property. The deed is the piece of paper that conveys that right. So title is not a document at all. It's the strength of your ownership claim. Having clear title to property means that there's not going to be any unexpected claims on the property. I can tell you, there are plenty of times when someone has probated a will, they think they have clear title, something else comes up and they find out there's a tax lien or some other type of lien on the property. So it's important to keep an eye on your property and understand exactly if there's any claims on it. The deed is the piece of paper that transfers ownership to the new owner. I will talk on about this quite a lot in a few minutes, but filing a transfer on death deed is the easiest and least expensive way to transfer real estate to someone after you pass away. It's also perfectly good to prepare a will that is legally valid to transfer property after you pass away. Like I said before, if you don't have clear title, you can't get any type of disaster recovery assistance. You cannot qualify for property taxes. It's also important to have clear title if you want to get any type of loan for your property, if you want to have home improvements done. You may not have any clear title on any real property or be able to access financial accounts if you do not probate your loved one's estate. You don't, some people think that has to happen right away. You have the right, you have the right to probate a will or resolve somebody's estate for 4 years after they pass away. Please first take the time to care for yourself, to grieve, to celebrate that person's life. You don't have to go to the attorney's office right away, but it does have to be done. Typically, title is cleared through the court system. If someone died within the last 4 years, you need to probate their will or file an application for administration. If it's been more than 4 years, you can file what is called an application to probate a will as a muniment of title. That is a probate process where the judge finds that the will is legally valid and that the only thing that needs to happen is that the homestead needs to be transferred to the person named in the will. And there's another court process that is outside of probate. It's called a petition for adverse possession. So if your loved one passed away within 4 years, you can probate their will or file an application for administration. Like I just said, the probate process, the judge determines whether the decedent left a will that is valid and compliant with Texas law and determines that everything is handled correctly. You have an application for administration if there was no will. If it's been more than 4 years, you can do the muniment of title process. There still has to be a legally valid will. Every heir has to agree to probate the will. After the judge determines that it's a legally valid will and admits the will to probate, you record a certified copy of the judge's signed order, along with a copy of the will in the property records, and the title will be clear again. A lot of people have probably heard of adverse possession. It's the legal principle that allows a person to obtain ownership based on continuous occupation without permission from the legal owner for a specific period of time. There are several different laws that you can use to determine that you have property through adverse possession. Typically, you have to have cared for the property for 15 years. There are different standards depending on your circumstances. What is most important is that you have to have clear possession of the land. A common way that this happens is there's a vacant lot next to you. You keep it clean. Maybe you have a garden, or you have your kids play on the lawn. But you get mail at the property. Everybody knows that that is your property. It's very clear. You cannot use this process if you have permission to use the property. For example, I had a client who came to me because everyone in the family agreed that she could live at the house. She paid the property taxes. She took care of everything. They would not sign permission over to her to 100% own that property, unfortunately. Adverse possession was not available to her because she had permission to reside there. Another very common way to clear title, this happens typically when a home has been in the family for quite a long period of time. It's called an affidavit of heirship. It's a legal document that is used if someone did not have a will or the will was not probated. This happens when people just don't know that they need to probate, or, it's a family house. It's always been on our property. Then they get hit with a hurricane and they apply for assistance, or they apply for a property tax exemption and deferral, and they find out that this is still owned by your great grandmother. So what you do is you prepare what's known as an affidavit of heirship. It's a formal family description to explain who the current generation is that has legal right to the property. It has to be signed in front of a notary by two people who knew the deceased person well and knows the family history. Those two people cannot legally inherit from that deceased person. So this can be an aunt, a cousin, a longtime family friend. Most critical part is that you must include the full legal description, which is found on the deed. When everybody gets their property tax bill, there is a line that says legal description. That is not the full legal description. That is just the property tax description. If you use that on your affidavit of heirship, it is not a clear title. So it's very important that you get a copy of the deed, and you can get a copy of the deed from the county clerk's office in the county where the property is located. You can also go online. There's a very good website. I'm not affiliated with it at all, but I can vouch that it does work well. It's called texasfile.com, and it is very easy to locate deeds on that website. Harris County Clerk's Office does have a website where you can attempt to locate property records. It is not easy to search at all. Texas File is much easier. It's, I believe, $1 a page, just as if you get a deed from a county clerk, it's also, I believe, $1 per page. The affidavit of heirship is filed in the county property records where the property is located, and there is a small filing fee that varies by county. It's confusing to talk about when you hear affidavit thrown around all the time. There's a small estate affidavit. There's an affidavit of heirship. Small estate affidavit can only be used to transfer property to a surviving spouse or minor child. Harris County courts constantly get people who file small estate affidavits when their parents pass away. The judge is not going to sign it. The judge can't legally sign it. So you're out the $400 that it costs to file that small estate affidavit, and you still have to go through probate. You can also use a small estate affidavit to transfer bank accounts. If the person passed away and you don't need to worry about real estate, but they had a bank account that didn't have a beneficiary name to it, you can use a small estate affidavit to get access to those funds. Affidavit of heirship is the best, least expensive way to transfer a home to a surviving spouse, adult child, or other transferees. You can use an affidavit of heirship instead of probate if this was the heir's only asset, if this was the deceased person's only asset. Probate, filing fees, roughly around $500 plus attorney's fees. Small estate affidavit, I believe, is $400. You don't have attorney's fees with it, but like I said, it only works in very limited situations. Affidavit of heirship is going to be roughly about $50 for the filing fees. Once I help people get their property clear, I remind them of the difficulties they had in transferring their property and say, let's please make sure to prevent this problem in the future. I love transfer on death deeds. It's the simple, inexpensive way for a homeowner to transfer a home or any other real estate that they own upon their passing. If you use a transfer on death deed, it does not affect the owner's rights whatsoever. They can still sell the property. They can still use it as collateral for a loan. They can get their property tax exemptions. It's their house, 100%. The beneficiary has absolutely no rights until the person passes away. The owner can also change a beneficiary or cancel the transfer on death deed entirely. It's not set in stone that that's how it has to be. The most important part, there's two most important parts. You absolutely have to have, again, the correct legal description, the one located on the deed, not on your property tax bills. And I know I sound like a broken record, but I have given classes on how to prepare a transfer on death deed, and people come up to me afterwards to take a look at their transfer on death deed. I've said 5 times, do not use your property tax description, and that's what they use. So be sure that you're using the description on the deed. And also, the transfer on death deed has to be filed before the person passes away. You know, if you think, I prepared the deed, I'm just going to put it in a safe place with my will, that is an invalid deed. It has to be filed. Transfer on death deeds have been valid for about 7 or 8 years now. Longer, if you look longer back than that, most people use what's known as a ladybird deed. You hear about ladybird deeds a lot when you're dealing with Medicaid applications. A ladybird deed, the formal legal name is an enhanced life estate deed. The transfer on death deed is covered by a statute. It is a Texas law. Ladybird deed is more informal. It's called common law. It's just something that people have been doing. The one benefit of a ladybird deed is it can be signed by someone who holds a power of attorney. With the transfer on death deed, the homeowner has to have capacity to sign that deed. It cannot be signed by your power of attorney. Ladybird deeds are good in about 5 states, including Texas. I believe that most states allow transfer on death deeds. And an important thing and a great thing about both ladybird deeds and the transfer on death deed is that you don't have to go through probate, and it protects your home from Medicaid estate recovery. If someone uses Medicaid, once they pass away, Medicaid has the right to try to recoup the expenses that they spent to care for that person. So what happens if you go through probate to transfer real property is you will have to reach out to the Department of Health and Human Services to determine if Medicaid has a right to any of their property. This is only if there's a homestead. If there's no homestead, there's no Medicaid estate recovery. Medicaid will send a letter that you file with the court that explains that they either are or are not seeking reimbursement. Medicaid will not seek recovery if the house is transferred outside of probate. So that's where the Todd and the Ladybird deed are excellent, because it doesn't go through probate. So that asset is protected and it stays within the family. I'm not going to go through all of this. Nia will send you an excellent email that includes a video, a recording of this presentation, and you can review this slide. But here are the differences between the Todd and the Ladybird deed. Todd gives much greater title to someone. A Ladybird deed doesn't give any warranty of title. With a Todd, it gives more warranty, which is a bigger guarantee that you have clear title, that this person had the ownership right to transfer this. Another great thing about Todd's versus Ladybird deeds, at this point, Medicaid has a 5-year look back rule. What that means is when someone applies for Medicaid benefits, Medicaid looks through any property transfers that happened in the last 5 years. So if, for example, you thought, well, I'm going to be moving into a retirement place. I'm going to move into a senior center. I need more care. I'm just going to deed the house to my kids. Please do not do that. Medicaid will consider that a gift, and it will take you so much longer to qualify for Medicaid benefits. TODs are not subject to that 5-year look back rule because you retain 100% ownership of that house. A transfer on death deed is one probate procedure that does not require an attorney. On our website, we have a transfer on death deed toolkit that provides you with detailed instructions and the state's form on how to transfer your property. Again, please be sure to get a copy of your deed so you'll use the correct legal description. Otherwise, the transfer on death deed is not valid. And again, it protects your home and your family from Medicaid estate recovery. We are blessed with so many resources in Harris County. Our website provides statewide information and advice. Earl Carl Property Preservation over at Texas Southern University is a great resource for estate planning as well as helping you transfer and clear titles. Lone Star Legal Aid and Houston Volunteer Lawyers are wonderful attorneys that are available for any non-criminal legal issue. Legal Line through the Bar Association is a great resource for anyone. Now, the first three legal programs are legal aid type services. So they are for low income individuals. Do not automatically count yourself out. You should always apply and see, because especially Lone Star has a lot of exceptions to their to what they can do. They have a lot of flexibility depending on a person's circumstances. Legal Line can help anyone. You need to look for it online, and you can sign up and you get a free consult with an attorney. That attorney cannot take your case, but they can give you legal advice, and it's a great way to have an understanding of your legal program, legal issue, legal problem, without having to pay for an attorney. Houston Lawyer Referral Service is excellent. The State Bar has a lawyer referral service as well. They have lists of attorneys that will take cases at a lower cost. Also, you get a $20 30-minute consult to talk to that attorney, determine if they're a good fit for what you need, and you may be able to have your question answered in that 30-minute consult. Thank you again for your time. I will be sticking around till 3 o'clock, and I will also answer questions in the chat. I'm going to pass it over to Miss Mabel and our tax questions.
All right, thank you, Lisa. I'm going to share my screen right now, and as I mentioned earlier, I hope to fill in some of the blanks that Lisa may have left in terms of how property taxes play an important role in the inheritance process, as well as just providing some useful and helpful information about the appraisal district, how it operates, and as a homeowner, some things you may very well need to know. So again, my name is Mabel Menifee, and we're going to talk, as I said before, a little bit about property taxes as soon as okay, let's see here. There we go. And there. So hopefully everyone can see my screen now. So anyway, let's get started. Just wanted to add a little bit of something here about in terms of for those of you who may be new to the state or maybe new to property ownership. One of the reasons why do we have property taxes in Texas? Well, one of the reasons obviously property taxes support a lot of the services that we've become used to in terms of living as part of our community, and that includes the police departments, the school systems, school districts, fire departments, streets, roads. They pay for all of those local services that help make our community work. In Texas, they play a little bit of an outsized role than they may in some other states because there's no state income tax. So that money does not go up to the state and then be redistributed. You are taxed locally by various jurisdictions. There is a statewide law that kind of governs how CADs operate, and that is those are laws part of the Texas Property Tax Code or laws that are passed by the Texas State Legislature. You may have heard the recent legislative session that there have been a few changes made in terms of property taxes, and so that is the statewide organization that does have oversight is the Texas Comptroller's Office. Appraisal districts, what we primarily do is we value property. We appraise all the property in that county, whether it's residential, commercial, maybe it's agricultural or industrial. And we are required by the tax code to do so at 100% of market value. We a special date in terms of when your property is valued on what date, it's January the 1st. So whatever the condition of that property was on the first day of the year, that is what the value is going to be based upon. The other thing that the appraisal district does is administer exemptions. And we're going to talk a little bit more about that. Exemptions are primarily a discount on the property taxes, on your property taxes. We also certify those appraisal rolls. And what that basically means is that once we have determined what the value of property is, the market value of property within the county, we've settled majority of any appeals or protests, and that information is passed along to the taxing jurisdictions. What I mean by taxing jurisdictions are, of course, those entities that you receive a tax bill from, your school district, city, county, etc. So we pass that information along to them, and then they are the ones who set their budgets based on what they're going to need to do that following year. And then they calculate, set their budgets and then decide if they need to increase the tax rate for that jurisdiction, leave it the same, or maybe even decrease it. One of the reasons there are certain dates and deadlines, because I mentioned to you earlier, we do this annually so that the taxing jurisdictions will know the certified value of property in the county. And that's why we have this important calendar that we tend to follow. And in some cases, property owners will need to follow as well. One of which is one of the most important being the protest deadline. When you get that annual valuation notice from HCAD, you have until May 15th, if you disagree with it, to file a protest or an appeal. That's the only way you have the opportunity for any value change to occur for that year before that information is handed over to the jurisdictions. You also, if you get it late, say you get it after May 15th, then you always have 30 days from the date of that notice that you received, that valuation notice, to file your protest. So whichever one comes later. And then, of course, tax bills are mailed out in the fall. From the Harris County Building and Collection is handled by local tax assessor collectors, which is why you're going to be hearing from Shay shortly after me from the tax office. And then, of course, those taxes are going to be anything not paid by February the 1st becomes delinquent, and penalties are assessed for that. So again, HCAD, how do we do that? We are responsible for 1.9 million parcels of land in Harris County, in case you were interested. And we actually serve over 500 taxing jurisdictions. You may pay taxes. Your tax bill will only reflect usually around 4 or 5 of those, but depending on where you live in the county, you're subject to taxation by different taxing authorities. So the annual value notice. Okay, this is what we're going to be looking at in terms of the notice that a property owner receives annually, and usually around late March to mid-April. They're going to get that annual value notice from HCAD, and again, that's going to be the value, the market value when you look down here on that second line, the market value, excuse me, is what HCAT is required to determine and provide to the homeowner each year. And that's basically the value at which a property would be willing to sell to for a willing buyer on the open market. So it's going to be an open transaction, market transaction. And we establish that market at that annual value based on what properties are selling for in that area that are of similar characteristics and size. Now, the other part of that annual value, notice where you're going to see a number, is the appraised value. That is the number that is used to calculate your tax bills. So it could be the same as market value, particularly if there are no exemptions on the property, but it may be lower because there have been exemptions on the property, and it could be lower because of how long those exemptions have been on the property, and as well as a number of factors that roll into that, like for instance, a 10% appraisal cap that you get. We'll talk a little bit more about the cap in just a minute. And as we go into a little bit more discussion about exemptions, which I've referred to several times, these are going to be the things that you're going to want to make sure that if you're inheriting a property, you're going to want to make sure that the exemptions reflect the new owner's eligibility for those exemptions, and not the deceased homeowner, not the previous homeowner, because exemptions are typically based on certain criteria, including whether it's their primary residence, how old they are, that sort of thing. So we're going to dive into that just to kind of help you all understand why it's so important to pay attention to these when inheriting property. And if you're a new homeowner, why it is important to know about these as well. So exemptions are administered by HCAT, as I've said. They basically exempt a portion of the property's value from taxation. And it's basically for your primary residence only. You can only, in the state of Texas, you can only have exemptions on one property. And this is the amount, once the exemptions are taken into account, that's how your tax rates are determined. Give you an example. Say your home is worth $300,000, and you have an exempted amount, say on school taxes of $100,000. So on your school taxes, your taxes will only be calculated on $200,000, not $300,000. So as you can see, that reduces the taxable value for that purpose. So the most general one is going to be if you own and occupy the home. Everyone has this one, or should. It's the general resident homestead exemption. And there's also the over 65, which is an additional exemption that general resident homestead property owners get once they turn 65. And then there's the over 55 surviving spouse that just protects the surviving spouse from having to lose those exemptions that they may have already had on their property because the other spouse was already eligible for the over 65 and they were receiving it. There is a disability exemption, and there are several types of disabled veterans exemptions available, as well as other service-related exemptions that may apply to first responders and survivors of veteran survivors and the like. The general resident homestead exemption, very easy to get. If you qualify, you just, as I said, you need to own and occupy the home. The home has to be owned and occupied as a primary residence. And that may have been because they did in fact provide the appropriate documentation to HCAT, which is proof of ownership, usually your name on the deed, as well as a copy of their driver's license, which has the address on the license has to match that of the property. One of the important things that this one does is provides that 10% appraisal increase cap, which protects homeowners from rapidly rising property values and being hit with additional taxes because of that. The general resident homestead exemption provides you with a 10% appraisal increase cap. That means that you can never, your appraised value will never go higher than 10% if in fact you the property value went up. It never goes higher than 10%. It stops there, regardless whether your value may have risen the previous year 15, 20, 25%, which we've seen that quite a bit in recent years. You also get $100,000 school tax exemption, and that's by state law. School districts have to give you that amount. Some school districts may offer an additional exemption amount. Typically, many do, because your school taxes are probably the biggest portion of the taxes that you pay. I do want to bring it to your attention that there is a ballot referendum in November that has been placed on the ballot across the state by the legislature, in which you'll be allowed to vote on whether or not you want that $100,000 exemption will increase to $140,000 for people with general resident homestead exemptions, and for homeowners over the age of 65, it's going to increase even more. So the over 65 disability exemption, talk a little bit about that. And generally, in a lot of cases, that may be something that you will be dealing with for an individual, for a relative whose property you could be inheriting. You qualify for that for the entire year that you turn 65 as a homeowner. The disability exemption, very similar benefits to what you get as over 65, and you would qualify for that once you were declared disabled, or you could prove your disability by by the Federal Old Age Survivors and Disability Insurance Act, which means that you would be receiving Social Security disability. Not everyone receives Social Security who may be disabled. So there are also other ways for them to qualify. That includes providing HCAT with a physician statement that your doctor would fill out and return to HCAT, providing that information, certifying that you are disabled. So some of the additional benefits for the over 65, remember I've already described the ones that you receive with the general resident homestead exemption. The additional benefits with the over 65 that would be the school tax ceiling or freeze, meaning your school taxes are going to freeze at whatever they were the year that you turn 65. They can go down if the value on the property falls and be reset, or the only way they can go up is if you were to make substantial improvements to the property. And by substantial, I'm not talking about regular maintenance. That involves adding square footage, or you to add a room, or you to do something fancy in the backyard, like build a swimming pool or add a tennis court. And that, of course, is going to add some additional value, in which case your freeze would be recalculated at a higher rate and then reinstated. You're also eligible, obviously, you've got the general resident homestead exemptions, and you're also eligible for a tax deferral, as well as seniors are also able to pay their taxes in installments without penalties. Shay's going to talk a little bit more about that, how that payment process works, in just a few minutes. And then again, depending on where you live in the county, you may have other additional exemptions that are going to be granted by the city or the county or other taxing jurisdictions. The over 55 surviving spouse just means if the surviving spouse is 55 years of age or older on the date of the other owner's death, then they will be able to continue to receive that same exemption with no interruption, and they'll be able to continue the school tax ceiling. It can also transfer to a new home, and again, eligible to pay tax deferral and to pay taxes in installments without penalties. So as you can see, on some of these exemptions, particularly for a person who's moving into a house they just inherited, it's important to know what these are, so that you can make sure that you're able to square it with the appraisal district and in terms of your records, what you are eligible for versus what the previous property owner had on the property, because once that information is compiled by HCAD that there was an ownership change, then they'll look into, you would be liable if you had gone 2, 3, 4 years without having changed your eligibility, and you were paying those lower taxes that you were not eligible for as a new property owner, then you could be required to pay some of that tax money back. So it's important to understand and protect yourselves by knowing this information. The immediate resident homestead exemption. So this one is, I'm going to throw this one out here because it's just for people that may be considering buying a new home or moving into a home that is new construction, or you're moving into a home where the previous owner had no exemptions. In that case, you could actually receive your exemptions early, and they would be prorated the month that you moved into the home. And so you would say, for instance, you moved into the home in April of the year, then you would only be liable for property taxes for 8 months. Now, it's important to know that that's only the case if the property, as I said, did not have any previous owner with exemptions, or it's new construction because exemptions had never been granted. And in which case, if there was a previous owner, then you would simply be able to maintain those exemptions that the previous owner had for that year. Then you would be granted the full amount of exemptions the following year. Important to apply for that with HCAD. And it's important to remember that you need to apply before the first anniversary of the date you moved into the property. Otherwise, you would not be eligible for that. So let's talk a little bit about the airship exemption, a question that some of you may have actually been waiting for. So airship exemption, there is an opportunity for, if you are moving into a deceased relative's home, one of the problems that is often encountered is that the deceased person did not leave a will or specify who would assume ownership of the property once they had passed away. And this often happens as properties are passed down through generations without a clear or an updated title. When a grandparent or parent dies and they leave those multiple heirs to share ownership, sometimes it can be very difficult to decide who's going to pay for what. But oftentimes we have people who are living in the home. You may be living in the home. You're taking care of it. You're maintaining the property. Maybe you have siblings living off somewhere who have their own exemptions on the property that they own. Or perhaps you have another relative living with you, and you've been unable to claim that homestead or the over 65 exemption because you didn't have 100% ownership of the property. Now, when you do fill out the application now, there is an opportunity to receive the exemption at 100%, and it would not affect the ownership interest of any of the other heirs to the property. It simply provides you with the opportunity to receive that benefit of having the exemptions at 100%, and it helps you maintain the property. Now, how do you get that airship exemption? On our exemption application, our homestead exemption application that you would file with HCAD, there's a section on there, and the application is number 11.13, but we merely call it the homestead exemption application. Under section 3, there are a couple of questions that you can see that are highlighted down here that say, is the property for which the application is submitted an heir property? Were you to answer yes to that, and then do other heir property owners also occupy the property. And if you were to provide yes to that, then that triggers a certain set of procedures that you would need to follow in order to obtain that airship exemption. There are a number of, and that would include an affidavit establishing your ownership interest in the property. Of course, the death certificate of the previous owner, copy of the property's most recent utility bill. Some people might ask, well, why do you need that? And that's simply to verify that the home is being occupied. And then, of course, a citation of any court records relating to your ownership of the property, if available. Now, if this seems confusing, please do not hesitate to contact HCAT and ask to speak with someone in one of our exemption specialists. And they will, of course, be happy to walk you through this to make sure that you are getting the exemptions that you're eligible for. So feel free to contact HCAT if you have any questions about this, but the instructions are also going to be on our website, as well as the application that you can download and fill out. Now, I did mention there are several veterans exemptions that you maybe want to be aware of. If you are a veteran and moving into assuming ownership of a property, and these are listed here. There's a total VA exemption, a disabled veteran spouse. There's one for another disabled veteran, depending on your percentage of disability. There's one for surviving spouse of veteran's disability that can be transferred. And there's also the a certain exemptions that a veteran survivor may be eligible for. So keep those in mind. If you were to contact HCAT, we have a dedicated helpline for veterans that you can leave your information with, or may be able to speak with someone directly at that time. But keep in mind, help is available if there's confusion about what veterans exemptions are out there. So quickly, how do you apply? Very easily, you can do that paper form that we have in the office. Most of our forms are on, all of our forms are online, but most of them are fillable, particularly the exemption application. If you are applying as a new homeowner, you can also use the mobile app for that. I don't necessarily, it's not recommended for the immediate homestead exemption. However, for general resident homestead, yes, you can use that, or you can email it in. In other words, you can download that application. It's fillable online, and you can send it back in through email. There is also, I wanted to mention, a how-to video on our website at www.hcat.org. You can find it under forms. You can use this video. This video will talk you and basically walk you through the process of filling out the form as you do it online. And that way you can send it directly into HCAT, along with uploading a copy of your driver's license. Or in the case, if there are two people on the deed, then that are living there, couple, you would want to include a copy of their driver's license as well. And that's very important to remember, because a lot of people tend to forget they only send in one driver's license and there may be two names on the property. And so that would cause a delay in processing. So you want to submit all of that at once to make sure that your exemption is processed in as quickly as possible. And that's can usually be done in anywhere from 4 to 6 weeks. Additional information about some of the other exemptions that I've talked about is also available on our website at www.hcat.org. Another thing I wanted to mention, if you are a new homeowner, please be wary of any information that you might get from an organization saying they can save you money and get you a homestead. A lot of times they'll call it a designation of homestead, and they're charging a fee for it. acquiring that exemption through HCAT is absolutely free, so you do not have to pay a third party to get for the property owner to get their exemptions. All they need to do is fill out the paperwork and provide the proper documentation that they are eligible, in fact, eligible for those. So this is something that you're going to receive, and I want to bring this to everyone's attention because it's important if you are in an inherited property. And maybe you've just moved in. Each year, HCAT sends out this little postcard, little white postcard, as you can see here, with writing on the back and front. What it does is it's our way of verifying that the homeowner continues to be eligible for the exemptions that are on our record that they've applied for. If in fact you're a new homeowner, you may not be eligible for the ones that for the person that once lived there before you. In which case you would need to contact HCAT and make sure you get the process rolling to correct that. Maybe you need to apply for your exemptions, but keep in mind this is sort of a reminder, an annual reminder for folks that these are the exemptions you have, and you want to make sure that they are correct. If they're not correct, then you want to contact HCAT immediately because, as I mentioned earlier, you could be looking at having to be back billed for taxes because you were receiving an exemption which you were not eligible for, and they can go back as much as 5 years. If you are a homeowner and you're familiar with this and you don't recall receiving it this year, or one you go, I don't know what happened. I haven't seen that, because they're typically they are going to be mailed in December or early January. And if you don't recall receiving one, keep in mind that something could have happened at the post office, because these are not allowed to be forwarded. They are returned to HCAT if they don't go to the, if they aren't received in the mail by the homeowner, they get it returned to HCAT. And at that point, the appraisal districts are like us are required to look into whether or not that homeowner is still legitimately occupying the home or still in the home. And if they're not, then those exemptions could roll off the property. So it's always helpful to just kind of, if you don't remember receiving this, give us a call, or maybe go out and check your information on our website. I do want to show you what our website looks like. This is it at www.hcat.org. You can see up here the second blue line where you have about the fifth one over is forms. That was one you can click on and get just about any form that you would need to fill out. We also have, again, some important information under help, where you can find helpful videos about different processes. Again, you can also make an appointment online if you want to come in for a customer service chat, or you want someone to call you back regarding some questions that you may have. Our website again is www.hcat.org. And this is additional contact information. We're out on the Northwest Freeway at the Hollister-Tickville exit. However, we try to help. We try to do as many things as possible so that you don't have to travel down 290 to get to us, that you can do things over the phone or online. It's our general phone number, again, our website. And online, there are 2 places you can, if you have an owner's account, you can contact us through the hcat.org contact us form, and you'll be able to fill out some additional information, which will then put you in touch with the specific specialist or department that would need to assist you. You can also email us at help@hcat.org. And that concludes my presentation. Appreciate you listening. I do want to mention that my colleague, Ashley Washington, is also in the chat room, that we can help answer any questions, additional questions, and we look forward to sharing that information with you. Thank you so much.
Hi, Mabel, I just want to piggyback right quick about the airship. With the airship property, you do need documentations, and which that includes filling out the application, a copy of the death certificate, and a copy of the utility bill showing that there is service at the property. It does not have to be on. It doesn't have to have the heir's name on it. We just need to know, hey, this is the service address and there is a service on there. Also, I did see something about the chat about how can I get exemptions if I already have exemptions on my property. If there is multiple heirs, one heir can stay at the home and claim the exemption at 100%. Just everybody has to sign the affidavit agreeing that that property, that heir can stay there and that they can claim that exemption on the account. Unfortunately, if you're claiming exemptions on your property and you're the only heir, you do not qualify for the exemption, but your cap that your I was gonna say your 10% on the property would not go up. It'll stay. I think Mabel, you touched bases on that. I forgot what type of exemption. I mean, what kind of cap that is. But
Appraisal increase cap.
the appraisal increase cap. So so your bill won't be that high, but that is something to think about. And as heir wise, I mean anybody 18 years or older can stay there. We just need an affidavit of heirship showing that they are the heir of the property, and we can go from there.
All right, thank you. Yeah, because it's very particular interest, I would assume, among some of our listeners. So thank you very much for additional clarification, Ashley. And again, we'll be on in the chat answering any additional questions. And now I'm going to turn it over to Shay.
Okay.
Thanks.
Shay,
Thank
Shay,
you,
just just before you get started, is it okay if we go ahead and have Miss Lisa to answer any questions that anybody might have for Miss Lisa before she leaves? Because I know we only got a couple of minutes. I wanted to go over a couple of the questions that were in the chat that some people might not be looking at. Also, for the folks that are joining online, they can't see the questions in the chat. So I want to go over a couple of those so everybody could hear the explanation, Miss Lisa.
Thank you so
Um,
much,
No,
Shay.
absolutely. Yeah, no
Okay.
problem. I'll put myself on mute. Thanks.
Is there a statute of limitations on contesting a will? What if the individual who wished to contest has already benefited from the will?
2 years is the statute of limitations. There are little bits of exceptions. So if you have any reservation about a will, talk to an attorney as soon as possible. But in general, it's 2 years, and you can still contest a will even if some of the assets have been spent.
Okay. Another question, how do you find out if there's a lien on your property?
You need to do a title search, and the easiest way to do it would be to visit the Harris County Real Property Records. I'm gonna show real quick their website. I put it in the chat, but so nobody gets confused here, I can show you it. It is not an easy search, unfortunately. Can you see my, oh wait, no, I'm not sharing.
Not yet, no.
Come on. Now I'm sharing. Okay, so you want to go to the Harris County
It's
Clerks.
still loading. Okay, no, there it goes.
And I just had this up. You want to go to the Harris County Clerk, not the District Clerk. And I am grateful that they have a good website. Not all counties do, but oops, did not mean to go there. It is confusing to search the property records, but you want to go to the Harris County Clerk. And I'm getting all this junk.
Go up.
There we go. Sorry. I should have had it up before I shared my screen. So here's her main website. And you go to search records. And this is where you search the real property records. You cannot search by address. You have to search by grantor or grantee. Grantor is the person who sold the property. Grantee is the person who purchased the property. So you have to search by name, and it is tricky. It is a tricky search. So the best thing to do is to I believe that you can go to their satellite offices. I would call them
And
and
and also, like, when you get to like the lot and block and the subdivision description, where you just were on the other page, if you're
Mhm.
not sure what that information is, you can go and look up the property on HCAD's website, and
Thank you. Yes.
it'll have that information on the appraisal district's website.
Yes, unlike the county clerk's website, HCAD is wonderful and easy to search. And so when I need to try to pull up somebody's deed online, I start with HCAD. You can look it up by address or by name, and that will give you the lot and subdivision, and that can help you with your search as well. You can call the county clerk's office. They do have a form you can fill out and submit to them to order a deed. You could also just call to make sure. I know you can go to their downtown office on Caroline. I believe you can go to some of the satellite offices as well and ask someone to help you do a record search.
Okay. What are tax implications if someone is interested in selling an inherited house?
I'm not a tax attorney. I cannot answer that question.
Oh, I see your response. I didn't go down far enough.
That's
Sorry.
okay. That is a great question, and you always want to think about tax implications as well as any other. For example, if you receive public benefits, you want to be careful about any extra cash that you had. So these are great questions to ask an accountant, a tax attorney, to find out about that.
My brother and I share an affidavit of heirship concerning my mother's home. I'm the only person in the home. My brother passed away. Should someone fill out another affidavit of heirship?
Yes, if you own airship property with other family members and some of those family members pass, you need to do affidavit of airships for that family member. So in this situation, the person needs to do an affidavit of heirship for the brother and list if the brother's married or was the brother ever married? Did the brother have children? So because right now she has what's called a cloudy title because she has her share of the house. Her brother's share belongs to his estate. It's in limbo right now. So she does need to prepare an affidavit of heirship for that brother.
How do you close a probate?
That is when everything is distributed. If you Most judges in Harris County close them once everything has been done. So for instance, in a probate of a will, once somebody files the inventory, the court usually closes that. With administration, once that the court has records that all of the property has been disposed of, they would close that. That person wondered if there was a check sitting out there for one of the distributions that somebody didn't cash, the probate technically would still be open because you wouldn't be able to close that bank account until something happened with those funds. This
And
again would be talk to your lawyer.
do letters of testamentary expire?
I believe they do eventually, but
Okay.
it's not a problem to get new ones. And it's
Oh,
not going in front of a judge, it's asking the probate clerk to issue new letters.
and do you have to pay for those?
Yes, I think it's $1 or $2 a page.
Okay. Um, let's see. If I wanted to give my son to my house while I'm still living, how do I have to do owner finance, or can I just gift it to him, or what do I need to do?
I am so glad we got this question. Please do not gift your house while you were still living. If you need to apply for for Medicaid in the future, you will have extreme difficulty doing this because even if you go through financing, they're going to look at that very carefully and determine if he paid fair market value. The best thing you can do is do a transfer on death deed to transfer that house to your son while after you pass away. Otherwise, you want to have an attorney or some other real estate professional prepare a deed, and you need to talk with a finance person about the best way to do that.
Okay. Um, my friend has a deed to a property in hand, but his parents um but his parents' name are on both, but both parents are deceased. Siblings don't want to probate and they don't want to sell. He doesn't either, but not sure as how, what do they need to do in that
They need
instance?
to do an affidavit of heirship.
Okay.
We do have the forms for affidavit of heirship on our website, texaslawhelp.org. You don't need an attorney to do an affidavit of heirship. You do need to make sure you have the correct legal description. You have the deed, so you're good to go with preparing that affidavit of heirship. But affidavit of heirship will transfer the house to all of the living heirs.
How long does it take to even start an application for probate? Like, what's the beginning process like?
Well, the attorney does that, and it's not, if it's somebody who's done it before, it's fairly easy to prepare it. They need information, they need to know who all of the family members are. They need to know social security number, driver's license number, but the probate application itself is pretty straightforward. The law tells you exactly what needs to be in it.
And
It's
they
just that
can't do that themselves.
the courts are slow because we are a huge county and we don't have enough courts to handle all the cases we have. So Harris County has 5 probate courts. They're still very, very busy. So it's not anybody's fault. It's just, I'm living in a big city. Things take some time.
Can an heir represent themselves in probate court, or can
No,
they file an application
no.
themselves?
You absolutely have to have an attorney for probate court. It's because there's complicated legal requirements. Also, in probate, you're not representing yourself. You absolutely have the right to represent yourself. For example, in a divorce, in a any type of lawsuit where you're the individual party that needs to do something, you can represent yourself. Probate, it's not just you. The estate is a separate legal entity. That's why you have to have an attorney. It's just like if you have a business, you have to have an attorney. You can't represent the business. It's its own legal entity.
Okay. All right. So between the chat and the emails that I got, I think you just about covered everything. So,
All right. I'll stick around a little bit more if somebody wants to ask anything. I'll just head out shortly before 3. Thank you so much for your flexibility, everybody.
all right.
No,
Good deal. All right. From there, we're going to let you take it away, Shay. Go right ahead.
awesome. I get to start on the fun bits that everybody wants to know about. Unfortunately, that's not necessarily the case. It's all necessary, but it's not fun for most. But we're going to roll into property taxes. We're the office that collects and bills for property taxes for Harris County. As I mentioned before, my name is Shay Pinkowski, and I'm with the Harris County Tax Office. Annette Ramirez is our Harris County Tax Assessor Collector, and I'm going to go ahead and roll right into it. So we recently elected, when I say recently, this past year, elected Ms. Annette Ramirez as our Harris County Tax Assessor Collector. She served 23 years with the Aldine Independent School District as legal as assistance with overseeing the property tax collection for Aldine. So she comes with a wealth of knowledge, really versed in a lot of what she's. Yes.
We can't see your screen.
Oh my goodness. That would be important, wouldn't it? Let's see. There we go. I must have missed the button.
Yep.
But yes, perfect. Awesome. So we elected Ms. Annette Ramirez this past year. She comes with a wealth of knowledge. We're super excited to have her, and there's a lot of changes coming in this upcoming year with property taxes. So we're really excited for an interesting year. But we are here to help. So let's go ahead and get the ball rolling. The Harris County Tax Office, we serve multiple functions. My priority is, of course, property taxes, which is what we're talking about here today. But in addition to that, we are also the office that handles the documentation for renewal of registrations, as well as transfers of titles for vehicles, and maintaining voter rolls. So whenever you're getting registered to vote, our office is one of the offices that maintains those rolls and ensures that everyone is able to go ahead with that process. So we handle a lot of different things, not just property taxes. I was asked to mention that whenever you're trying to renew your registration for your vehicle, since I've already got a good audience here, you're no longer required to do a safety inspection. However, you are still required, as Harris County is an admissions county, to perform an emissions test on your vehicle. So just keep that in mind whenever you're going to renew your registration. You don't need a safety inspection. You do need an emissions test for most vehicles. So just keep that in mind whenever it's time to renew. So just as an overview, the Harris County Tax Office collects more property taxes on more than 1.7 million tax accounts. That's all these parcels of land, business, personal property, houses, you know, all of the above. And we collect more than $8 billion in property taxes this past year. We are constantly changing those numbers due to, you know, property values going up, more properties being built, houses, apartments, shopping centers, and our jurisdiction list continues to grow. But as our last count, we have more than 80 taxing jurisdictions that we disperse funds to, meaning that our office collects on behalf of these jurisdictions that support our necessary services with the public. But we are the office that collects the property taxes for these jurisdictions. So on your bill, you'll see an itemized list of what jurisdictions are being collected for your property taxes from our office. But in addition to that, you may have other jurisdictions that are not collected by the Harris County Tax Office. So please make sure when you're getting your tax bills here at the end of the year that you're verifying either through the appraisal district or through the maps that you have, but the appraisal district is going to be the more centralized unit for information, that you do not have any other bills that you would owe. For instance, you may owe to a school or a MUD or an emergency services district that we just don't collect for. So just ensure that you're having all of the correct bills either being sent to you or that you're ensuring to verify that these bills are arriving and that you're getting those paid timely. So recently, in the last 4 years, a lot of exemptions have increased. And as Ms. Mabel explained earlier in her presentation, exemptions are benefits that reduce your taxes, how much you pay in taxes. So Harris County increased their over 65 and disabled exemptions in the last 4 years from $229,000 to $320,000 for the Harris County. City of Houston increased it from $160,000 to $260,000 in the last 4 years. We've all seen homeowners have seen that nice increase for your general homestead exemption on schools from $25,000 to $100,000, and now they're going into voting to increase it again. So keep your eyes on your ballots, make sure that you're reading up on your Senate bills and seeing what effects could be made and what you would choose to vote for. We do recommend everyone go vote. But there is a lot of exciting stuff coming around. Ms. Mabel did mention earlier the proration of homestead exemptions, meaning that you don't have to wait for your first full year of living in a property to benefit from your homestead exemptions. They're able to do it at a prorated start from whatever date you gain ownership of that property. So, you know, keep that in mind if you're recently purchasing a home, if you're not sure what you're eligible for. And the appraisal district is able to help you get those exemptions that are applicable to you sorted out for you. So make sure that you're applying for them if that's something that you're eligible for. So this is what a lot of you will be used to seeing if you've paid property taxes before. If you've never paid a property tax before to Harris County in your life, this is what our bill looks like. So the front page is going to have, of course, as I mentioned earlier, they're going to have that itemized bill of what jurisdictions are being collected for, how much those jurisdictions are collecting, and, of course, the grand total of what all we collect for and how much it is completely, which exemptions are being applied. All of that information is going to be on your bill. At the bottom there is what we call our tax payment coupon. This is a perforated section of your bill that you can rip off and submit in with your payment, and that's whether you choose to come into one of our branch offices and make a payment in person, whether you prefer to send your check in to us by mail and make your payment that way. Either way, this coupon is really important because it has all of your information on it, all of the relevant information for your property, and it ensures that we are collecting on the correct location because a 13-digit number is easy to typo. So it's really good to have that information so you're not providing an account number that is incorrect, but also that you're making the payment accurately. So it's always good to have that payment coupon. Of course, if you need another copy, we're able to print it out for you, or you can see it on our website. In addition to the statement that you are mailed, There is another option for receiving your property tax statements, your property tax bills, and that is through an electronic tax statement. This is a statement that is emailed to you through an automated system in our computers here, and you are able to sign up on our website and request for those statements to be sent to you via email. Now, these emailed statements do take the place of the mailed statements, so ensure that if you're going to be doing this via an electronic tax statement, that you are aware that you have it and that you are expecting that to come through. But in addition to that, that you have access to that email. Don't use the throwaway email to set up for your electronic tax statements, because that's where your statement is going to go. It is an option for you on our website, as I mentioned earlier, and it's something that you would have to register for. So, please feel free. In addition to having the electronic tax statement and the mail, you're always able to look up your property tax statement on our website as well. You would only need either the account number, the address, or the ownership or the owner's name in order to search for that property. So, please feel free to look into that. Soon as mid-November hits is when we start rolling out with those tax bills. So you'll hear a lot from all branches that deal with property taxes about a taxable value and your tax bill. The tax rate is something that not a lot of folks talk about, but it is super critical in calculating your bill. So the way that property tax bills are calculated is by taking your taxable value, which is determined by the appraisal district. They set your property value and then determine what your exemptions are eligible for your property, which is subtracted from that property tax value. And whatever's left over is your taxable value. And that taxable value is multiplied by a tax rate. Each jurisdiction that collects property taxes determines their own tax rates. And our office, as I mentioned before, collects for over 80 jurisdictions. So whatever jurisdictions are applicable to you, each one of them will have a separate tax rate. Different exemptions will apply to different jurisdictions, so that might change. But in order to determine how much your tax bill is, we need that information. So we have the taxable value, we multiply it by the tax rate, and that determines how much you actually pay for your property taxes. So you'll see that the numbers that go into that calculation on your statement, but the tax rates are also available online, either on our website, on the Harris Central Appraisal District's website, and on the Truth in Taxation website as well. So all of that information is public. And that's actually what they're in the process of now, is determining what those tax rates are going to be. Homestead exemptions. Ms. Mabel explained it earlier in her presentation as well, but just so that we can all see a visual of what that kind of a difference can be when it comes to your tax bills, is on a taxable value for your appraisal value of $342,000 for a property, and that's just kind of an average number that we came across. A tax bill generally from the Harris County Tax Office would be about $7,155. Again, this does depend on which jurisdictions are applicable to your property, but that's about average. Now, with a homestead exemption, that gets reduced by a little over $2,000. So you see a pretty drastic reduction in that to begin with right off the bat, just having a homestead exemption. That homestead exemption is when the property belongs to you and you live in that property, and that's when you go and apply for that homestead exemption. So it can reduce your tax bill by a great deal. So that would reduce your property tax bill to a little under $5,000. Now, when you have the homestead exemption and you turn over the age of 65, or you are a disabled homeowner or a disabled veteran homeowner, that property tax reduces even further. So instead of collecting a property tax bill of a little over $7,000, we would collect a property tax bill of less than $2,000. So it is super important and super critical that if it is eligible to you and you are able to get that homestead and then later on that over 65 disabled or disabled veterans exemption, that you are able to have those exemptions applied to your account, because there's no need to pay additional property taxes that are not owed by you. So just ensure that you're making all of the necessary preparations for your property taxes and that all of the exemptions that you are applicable for are being applied to your account. At this moment, this isn't necessarily relevant because we have not had a disaster within the time specified for this to be applied to, but for future reference, if we are ever in a state of declared disaster, we have additional exemptions that are applicable and that are able to be applied to property. This is only relevant to property that has sustained at least 15% of the property's value and damages. It's an exemption application that you can fill out on the appraisal district website, and those forms all need to be submitted within a timely manner to the appraisal district's office. As I mentioned before, this isn't necessarily applicable right now because we have not had a disaster, thank goodness. But for future reference, for hurricane season, whenever that comes around, if we suffer through another freeze or a derecho or whatever the case may be, if we're called into a state of disaster, that is when this would come into play. So it's just kind of to keep in mind as you're going through your property tax season. Always, as before, include any documents, inspections, photographs, anything that can show what the damages are to the property are relevant when it comes to applying for this exemption. So just make sure that you're keeping track of all of your documents and your pictures. Now, Ms. Mabel did mention this in her presentation as well, but something that is applicable to property homeowners with the over 65 exemption on their property or the disabled exemption on their property is something called a tax limitation. And you'll hear this referred to as a tax freeze or a tax ceiling. It goes by a lot of different names, but to clear up any confusion, a tax limitation is a limit to how much the collector is able to collect for property taxes on certain jurisdictions. In our case, usually it's the school property taxes. So ISD, HISD, Pasadena Independent School District also collects one, Aldine, Klein, whatever the case may be. There is a tax ceiling for our over 65 homeowners with the homestead exemption and the over 65 exemption, or the homestead exemption and the disabled exemption, that limits how much we as a collector are able to collect on property taxes for that jurisdiction. The best way to explain this is with an example. So for instance, the first year that one turns over the age of 65, say their school taxes are being collected in the amount of $300. The following year, if the property tax calculations, like I mentioned before, would calculate to a higher amount, say $400 for your property tax bill, because the initial year of your over 65 exemption had a bill of $300, we would not collect over $300 on your property tax for that school. This, of course, is, as Ms. Mabel mentioned earlier, it changes if you have any type of new construction, if you're putting in a pool, a tennis court, whatever the case may be, adding square footage to your property, that taxing ceiling can change. But if the property remains the same and you are simply just making general repairs, not making any new construction, then that ceiling stays on your property as long as you're the owner of that property. So it is super keen to know that whenever you have that over 65 exemption, that starts to apply, and it automatically gets added on. You don't have to make any special phone calls, any applications. It's automatically put into your account, and that's why whenever you become over the age of 65, and you might start to notice that the calculations don't make sense. It's not just you, it's just you may have a tax ceiling, and on your statement it'll say if there's a tax ceiling or a tax freeze on that account. So just so everyone's aware of why those numbers might not make as much sense as they should, you can always call us and we'll be able to look at it and verify that information for you. Another benefit of our homestead with over the age of 65 or disabled homeowners or disabled veteran homeowners is a tax deferral. Now, a tax deferral is a postponement of your property taxes. A postponement meaning that these taxes are still due. You still, of course, get the exemptions that are applied to your account that reduces how much you pay in taxes. But when you have a tax deferral, even if you do have a balance due, you have an extended amount of time in which to pay those property taxes. In the case of deferral, that extension is indefinite, meaning that as long as you are owning and living and residing in that property, that deferral is active and can be put on your account and stay on your account, giving you additional time to pay without having as many fees. But in addition to that, avoiding any kind of foreclosure action or additional litigation that might have gone onto your account otherwise. So it is a 5% interest per year, which compared to our usual penalty and interest fees is quite drastic of a change. It's very low whenever you have that deferral on, which is why we always recommend if you are over the age of 65 and a homeowner and the house that you own is the house you reside in, that the deferral is a good recommendation, because while you may not always need it, it is better to not need it and have it than to need it and not have it on your account. As I mentioned before, this does prevent foreclosure and litigation action on your property. And for a lot of our over 65 folks, if they are, they have a limited income, they're not able to make the full payment in January, they have other necessary funds that they have to apply their payments to. But in addition, if you are out of town, if you forget, if you are, God forbid, in the hospital, this saves you from, like I mentioned, foreclosure action, but it also saves you from having to worry about paying all that normal penalty and interest that would get applied to your account otherwise. I'll say it, I've said it before, I'll say it again. It is a postponement. It does not cancel your taxes. It does not reduce your taxes. That's what the exemption does. The exemption is what reduces your property taxes. But the deferral can help you in the long run, and can kind of protect you and your property from that negative action that might happen from delay of payment. I mentioned this before, but your deferral must be on a both homestead and either over 65 exemption, disabled homeowner, or disabled veterans exemption in order for that to be applied. And you'll have to go and apply with the Harris Central Appraisal District in order to have that applied and put onto your account. But you need to have a homestead and over 65, or a homestead and a disabled homeowner, or a homestead and a disabled veteran. Just a quick note, when it comes to deferrals, before you go and apply with the appraisal district, please confer with your mortgage company. If you're still making payments on the house, if you just downsized into a smaller property and you're still making payments on that, verify with the mortgage company that services you that they allow you to have that deferral on your property taxes. Since banks do have an interest in property, they will sometimes not allow for you to defer your property taxes, and it can influence things with your escrow. So it's always good to check first, but just a little note there. So in addition to, as mentioned before, your deferrals, we do have other options for payments when it comes to making your property tax payments. And this usually comes in the form for folks who are not in a homestead, or people who have a homestead but not the over 65, disabled, or disabled veterans exemptions. And these are flexible payment options. These are a tool in which you can make your payments and so long as you've made your agreement within the necessary time, it can help you avoid foreclosure actions, it can help you avoid collection efforts, and it can help you avoid collection fees so long as that payment agreement is set before and your payments are being made before attorneys are put onto the account in order to collect for our office. So super handy, very helpful. Anyone can apply for a payment agreement unless you are deferred. Payment plans for homestead exemptions are applicable for, as I mentioned before, all homestead residences. You don't have to have an over 65 or any other exemptions in order to apply for this homestead payment agreement. We offer 12 to 36 months, so 12, 24, 36 in order to make those payments. And your terms include a 1% interest per month, in addition to whatever the original or the month that you create your agreement, whatever that penalty and interest is for that month. So you get a smaller percentage of penalty and interest when you create that general homestead payment plan. This can be for current and previous tax years, and for all payment agreements, your payments are due at the end of each month. So it's a monthly payment. You are able to pay before the end of the month, but you must make your payment before the end of the month. Our non-residence homes or our non-residence payment agreements will include any non-residence properties such as land. It would include business and commercial properties. So if you have personal property taxes, in addition to anything that is not falling under that category. So like a rented space, if you're paying the taxes on a rented space, or if you're renting to someone, it does not count as your homestead, but you are still able to have a payment plan in effect for that property. We offer 12-month payment agreements for these properties, and the penalty and interest accrues as normal. But as I mentioned before, so long as this payment agreement is kept or is made and kept prior to the collection fees being added to the account, then it avoids those collection fees and it avoids collection efforts on the property that way. So please feel free to give us a call, contact us. I'll put our contact information at the end if this seems like something that you might be interested in, if you would like to create a payment agreement, and that way we'll be able to go ahead and go from there and help assist you in getting that sorted. Another option for our over 65 disabled and disabled veteran homeowners with a residential homestead is something called a quarterly payment plan. And quarterly payment plans are eligible for those property owners who may not be able to make their full payment at the end of January, but they don't necessarily want to go into deferral actions, or they don't necessarily want to go into a regular payment plan. But the quarterly payment plan is a great tool. It splits your whole payment of property taxes into 4 equal payments, being due at the end of January as normal, the first quarter, second quarter end of March, third quarter end of May, and the fourth quarter at the end of July. And this helps a lot of folks who are just unable to make their full property tax payment at the end of January, need a little bit more time, but would still like to continue to make their payments as normal. So this is quarterly payment plan is really helpful for those over 65 homestead, disabled homeowner homesteads, and disabled veterans and surviving spouses homesteads. So we do have multiple payment options. We have our website, which is www.hctax.net. You are able to make your payments there, in addition to sending your payments into us by mail, giving our automated system a call, or by coming in person to any of our branch offices. We do take all forms of payments, so at this moment, we're able to take credit cards, debit cards, e-checks, and cash. And all of these options are available. If you're going online, of course, you can pay with card and e-checks. If you're sending it to us in the mail, please just pay by either a check or a money order. And if you're coming in person, any of the payment agreements or any of the payment methods are available to you except for the e-check. But if you have any questions about that, please feel free to give us a call. Come into one of our branch offices. There's 15 of them that are available to you, and you can make your payment at any of them. But we do have multiple options to whichever is easier for you. We are here to help. If you have any questions, if you have a situation that's specific to yours that you haven't heard about or that I haven't mentioned in this presentation, please feel free to give us a call. We are happy to help, and our job is to make sure that it's easy for you to pay your property taxes and to be able to get that taken care of. I know this question always comes up with Ms. Nia due to the nature of this presentation, so I'm going to scroll back just a little bit when it comes to the tax deferrals. And that is because when tax deferrals are in effect on your property, and this is just to cycle back because I know the questions are coming next, but whenever you have a tax deferral on your property, if you pass away and the tax deferral is still active on your account, whoever your heirs are have 180 days to make the payment of whatever the deferred taxes amount is. And then after that 181 days passes, we start collecting property taxes for whatever the balance is on your levy, plus the regular penalty and interest as if it had been accruing normally. So just keep that in mind. If you have the deferral, it's a really great tool, very handy, very helpful. And a lot of folks do prefer to tell their next of kin, their heirs, this is the situation. I have my taxes deferred. If you want to start paying on these deferred taxes now to avoid it in the future and to avoid having to pay it all at once later, please do. That is a conversation that we encourage you to have with your loved ones, especially if you are in the process of getting your, next of kin documentation together, if you're in the process of getting, any kind of will and estate documentation together, so that you make sure that they're aware, if you are under the deferral, that those taxes are due as they are deferred if they are paid within 180 days after the deferral being removed. After those 181 days, those taxes are going to be due with a lot more of penalty and interest than they were originally. But I just wanted to go ahead and mention that because it's a really common question and is one of those things that we like to advise people of, as they're preparing these documents for their test date. So I believe the next state would be to just start asking questions or answering those questions. Ms. Nia?
All right, cool thing. There was one question that popped up into the chat that Miss Lisa did answer. However, I am going to ask it and then read her response because it is a common question that is also asked. Can I file a transfer on death deed if my house has not been completely paid off yet? And what is the difference in a ladybird deed and transfer deed, and how do you clear a cloudy title? Her response to that was, yes, you can file a transfer on death deed before your home is paid off. The other question was answered throughout the presentation, so I don't want to repeat it. Then I don't want to convey or come across as I'm giving incorrect information or even giving you legal information. But that question is answered, and we have gone over that a couple of times. And she has given some reference to the documentation, the affidavit of heirship, and so on. And she reviews how to get that done. So that recording will go out to you so that you can go back and watch that part. Is a and people call it quick claim deed, but it's called a quit claim deed legal in Houston. It is legal, but does not convey a clear title to the property. Please consult with an attorney to prepare your deed. It's easy to make a mistake on a deed. So just know that also when you go to being a licensed realtor, when you go to try to sell a property or whatever that has a quit claim deed on it, title companies hate that. They hate that because it does not, it's basically a form that somebody has, filed with the county clerk's office to remove somebody else's name or to take a name off when it really doesn't. It takes a lot more digging than that to actually to make sure that ownership is actually switched and transferred the way that it's supposed to be done. So that is not something that is typically recommended. However, as she expressed, definitely contact an attorney about getting that done because it is easy to make a mistake as it relates to that. There weren't any other questions in the chat, and I know we are just about over, or we actually are over our limit. I wanted to go back and make sure I didn't miss any
I see
questions.
one. I see one, Nia, for can a person get a refund for overpayment of property taxes if it's never been claimed and it's been more than 18 years? So there is kind of a statute of limitations when it comes to overpayments, because once it's an overpayment, it becomes a refund. It gets issued out. We don't hold on to money that has been overpaid. So we try to get those refunds out really lickety-split type of ways. If for whatever reason we issue out the refund and never gets cashed, it gets, put back into the account, and, after I believe it's 3 years, it gets escheated and it goes to the state comptroller. So at that point in time, it's no longer funds that you would have to apply with us. It's something that you would have to go through the state in order to get those funds back. But that's not a question I get a whole often, so I wanted to make sure that I got it answered. But yeah, normally we don't hold on to funds that long. Normally, if you've overpaid property taxes and, only thing I can think of in that kind of situation is, if someone pays their property taxes in full and then retroactively has homestead exemptions added onto it type of situation where the property taxes value gets lowered, or the taxable value gets lowered, and then you know, it results in a lower levy of taxes and that refund stays on there, then normally that's, like I said, it takes a good bit of time for those to get put to that process, but we don't hold on to funds that long. We usually try to get those out lickety split because we do try to make sure that we're not holding on the money that doesn't belong to us, number one. And number two, we want to make sure that everyone gets their refunds back timely. So we don't keep those that long.
Isn't it a website that you can like unclaimed
Unclaimed
cash,
funds. Yeah,
unclaimed funds or something like that? That you can
Yeah,
go back and
it
do a search.
doesn't hurt to go out there and check it every time, because I've received a couple of surprises. You know, you
Yeah,
forget
yeah.
funds at a credit union and you closed it out, or in this.
Well,
yeah.
when my grandmother passed, there was when the nursing home that she was in actually owed her a refund, but because she had passed, there was no other address or anything
Direct.
like that on file for her.
Yes.
So we ended up finding that they owed that there was money that was there for her when
Yeah.
she
And that
passed.
is through the state comptroller. That is through the state comptroller. So if there's ever a refund, like I said, weird situations do happen. I will not say that they don't, but we don't try to keep on the money for that long. So as soon as it passes a certain limitation of time for us, we direct it over to the Texas comptroller, because then the Texas comptroller has to handle it and they have their own method of doing things. So we at the Harris County Tax Office don't hold on to funds for that long, but
And I
it might
will
be an
say-
unclaimed fund somewhere.
I will say that unclaimed property website is very easy to navigate.
Yes,
Mary.
very clear, very straightforward.
All righty. What else do we got coming up? I believe those were all the questions that we had. We didn't have anything else as on the social media pages. I don't see a question there. Other events that we've got coming up this month, evictions and knowing your rights. There were some new laws related as it relates to evictions and tenant rights that will drastically impact the way the eviction process actually goes. That presentation is going to be coming up on Tuesday. Um, I will get to that question in just a second. That presentation is coming up on Tuesday at 1 p.m. The tax office and the tax assessor's office will be doing another presentation on Wednesday, September the 24th, as well as the following day, we will have the property tax foreclosure presentation. So the attorneys from Lone Star Legal Aid will be giving a presentation about what happens if when there are unpaid property taxes and what that foreclosure process is like and what your rights are as it relates to that, as well as that Friday we'll have a voter registration laws and processes presentation on Friday the 26th. That one's going to be in person and on Zoom. And then we also Neighborhood Recovery will be also hosting a one of our financial capability workshops on the 18th. That's going to be an in-person presentation of mind over money and how finances shape your your mental wellness. So we want to make sure that we touch on finances and triggers and stressors that do impact your mental health, and how your mental health then in turn also impacts your finances as well. So we want to make that correlation and make sure that folks have some access to resources and other pertinent information that could be helpful in that regards. But that's going to be in person on Thursday, the 18th from 5 to 7 p.m. And we will be serving dinner. So make sure that you tell somebody, go online at nrcdc.org to get registered for that. The last question that was in the chat is how many years can you go back if you did not file your homestead exemption?
It's current year plus 2, if I am correct. Anyone at HCAD? Okay, yeah, it's current year plus 2. So
It's 2 years. So right now it's time. 2023 is timely right now for your residential disability over 65 vet disability, total vet disability. Now your disabled vet disability, the percentage, we can go back 5 years.
Oh, cool. All right. All right. So if you have more questions about property taxes, again, that presentation is going to be coming up on the 24th of September. We want to thank you all for joining us this afternoon. We hope that all of your questions were asked and answered. If there's something else that you could think of following this presentation that you may have more questions about, please feel free to reach out to any one of us, or we're here every month. So if you want to come back next month, we are here the second Thursday of each month with the inherited property and clearing title and probate concerns presentation. Again, the first part of the wills and estate planning session, where somebody, I believe, had the question about the difference between the Lady Bird deed and the transfer on death deed. She goes over that in that presentation as well. But I will say, Lady Bird deed transfers ownership while you're still alive. However, you do retain some of those ownership benefits. Transfer on death deed is what transfers the property over after you pass. So one is before, one is after. So that's just kind of the gist of it without getting into a whole lot of details because I'm not an attorney. Let me say again that information that we do present is not legal advice. So we just want to make sure that everybody gets that as you know, that they know that as well. But I did want to make sure that that part of the question gets answered. But if you want more details about it, we do have that presentation that is also on our YouTube page at Amos Houston or at Neighborhood Recovery. You can watch the videos there. I will send the link when I send out the link of this recording. The link for the A Month of Service YouTube page will be on there as well. And you can go back and watch other presentations that we've had in the past as well. If there are any workshops that we do not currently offer that you guys may be interested in, please reach out to us. Let us know. Provide us with your feedback. If anybody has a story that they'd like to share of how beneficial any of our presentations have been, we are in need of those kinds of stories, and we would love to hear from you guys, whether it's this presentation or other ones. If you guys could share that information with us, that would be great. Again, we are, as we're planning for the remainder of the fall and then into the first of the year, your feedback is what allows us the opportunity to kind of diversify and change up our presentations or continue on as needed based on your feedback that we have. So we do welcome that as well. So we are going to give you guys the rest of your afternoon back. We hope to see you all at other presentations. We want to thank you again for joining us. Thank to all of our presenters, our partners with Shay, Harris County Tax Office, Ms. Mabel with the Harris Central Appraisal District, also Ms. Ashley Washington with the Appraisal District for helping out in the chat and also giving her expertise, and Ms. Lisa Nelson with the Texas Legal Services Center for her presentation as well. So on behalf of A Month of Service, you all have a wonderful day. You take care of yourselves, you stay safe, and we will see y'all next time.
Thank you. See you next time. Bye-bye.
Thank
Thank
you
you.
so much. Have a great day, y'all.